Imagine waking up one morning, checking your email, and finding a letter from the Department of Justice. Not about your green card, not about your visa, but about your citizenship. The citizenship you already received years ago, the one you thought was permanent. That is exactly what is happening right now, in February 2026, to real people, in American cities. And if you think this cannot happen to you, or to someone you love, I need you to stay with me for the next 12 minutes, because what USCIS and the Department of Justice have quietly set in motion could be one of the most significant shifts in U.S. immigration enforcement in the last 2 decades. This is not a rumor. This is not political commentary. This is happening right now. And today, I am going to break it down for you, step by step, clearly and factually. My name is Raymond Crivello. I am a senior immigration analyst and consultant, and on this channel I break down complex immigration developments into clear, fact-based analysis that you can actually understand and use. I do not do fear, I do not do speculation, I do policy, law, and facts, because that is what actually helps you protect your future. Before we go further, please understand this. I am not your attorney, and nothing in this video is legal advice. This content is strictly for educational and informational purposes. Every immigration case is different, and you should always consult with a licensed immigration attorney about your specific situation. Now, let us talk about Operation Twin Shield and why Phase 2 of this operation should be on every immigrant's radar right now. Operation Twin Shield was originally launched by USCIS, the United States Citizenship and Immigration Services, as a targeted enforcement initiative designed to identify and prosecute immigration fraud. The name Twin Shield refers to its dual mandate, protecting the integrity of the immigration system and protecting national security simultaneously. When it was first announced, many in the immigration community assumed this was standard enforcement activity. Background checks, visa fraud cases, the kind of thing that happens quietly, at the border or in backlogs. But here's where this becomes critical. Phase 2, which is now actively underway as of early 2026, is not targeting undocumented immigrants. It is not targeting visa overstays. It is targeting naturalized citizens, people who went through the entire legal process, people who took the oath, people who have been carrying a United States passport, in some cases for years. USCIS, working jointly with the Department of Justice, is now reopening citizenship cases where there is reason to believe fraud occurred at any point in the naturalization process. And the legal authority they are using to do this is called denaturalization, one of the most serious and least understood actions in U.S. immigration law. Under the Immigration and Nationality Act, specifically Section 340, the government holds the authority to seek revocation of naturalization if it can establish that citizenship was obtained illegally or through willful misrepresentation. This is not a new law, but the scale and speed at which it is now being applied, that is what is new. Let me give you a concrete, real-world example of exactly what this looks like in practice. On February 20th, 2026, just days ago, USCIS and the Department of Justice filed a civil denaturalization complaint against Philippe Bien-Aime, the former mayor of North Miami, Florida. The complaint alleges that during his naturalization process, Bien-Aime concealed material information, specifically related to his criminal history and misrepresentations in his application. Under INA Section 340, those allegations, if proven in federal court, are sufficient legal grounds to strip him of his United States citizenship entirely. Now I want you to pause and absorb what I just said. A former elected official, a mayor of an American city, having his citizenship challenged in federal court. This case tells us something very important about the current posture of USCIS and DOJ. They are not limiting this operation to low-profile cases. They are signaling loudly and clearly that no naturalization is beyond review if fraud is suspected, regardless of your public status, your community standing, or how long ago you were naturalized. Now, the second major update from Operation Twin Shield, and this one is equally striking. On February 18, 2026, 2 days before the Miami case, federal authorities in Minneapolis, Minnesota, arrested a man identified as Morris Brown. And the details of this case are alarming for very specific reasons. Morris Brown had been serving as a Minnesota corrections officer. He was also a National Guard member. And during all of this time, while working in law enforcement, while serving in the National Guard, he was allegedly masquerading as a United States citizen while having no lawful immigration status whatsoever. USCIS Director Joseph Edlow, commenting on this arrest, stated that Operation Twin Shield relentlessly pursues those who seek to cheat our system. That phrase, relentlessly pursues, is not casual language. That is a policy declaration. And here is what makes this case important beyond the individual. If someone can fraudulently occupy a position in corrections and the National Guard without detection, that is exactly the kind of systemic vulnerability that Operation Twin Shield was designed to expose and eliminate. And that means the investigation is not slowing down, it is accelerating. But here is where this story goes even deeper. Twin Shield is not operating alone. On January 9, 2026, USCIS launched a connected initiative called Operation PARRIS, which stands for Post-Admission Refugee Reverification and Integrity Strengthening. And if you are a refugee, an asylee, or a green card holder who originally entered the United States through humanitarian channels, you need to pay very close attention to what I am about to explain. Operation PARRIS is specifically targeting refugees in Minnesota, approximately 5,600 individuals, who were admitted to the United States but have not yet received their green cards. USCIS is conducting what they are calling a reverification process, re-examining background information, re-interviewing applicants, and in cases where red flags are identified, referring individuals directly to ICE, Immigration and Customs Enforcement, for further action. Now let me be very precise here so there is no misunderstanding. The existence of this operation does not mean every refugee is a fraud case. The vast majority of refugees in this country arrived through an extremely rigorous vetting process. But what Operation PARRIS tells us is that the government is now applying a second layer of review, post-admission, and using modern data systems and interagency coordination to cross-check records in ways that were not previously possible at this scale. This is what many green card applicants are misunderstanding right now. The immigration vetting process does not necessarily end at the point of approval. For certain categories, for certain nationalities, for certain processing timelines, there is now an active mechanism in place to go back and re-examine what was submitted. Let me make this real for you. Not a statistic, not a policy summary, a person. Think about someone like Amara. She arrived in the United States 12 years ago as a refugee from East Africa. She went through the initial screening, the interviews, the background checks. She was approved. She built a life. She got a job. Her children were born here. 3 years ago, she filed for her green card, and she is still waiting. Now, under Operation PARRIS, Amara receives a notice that her case has been flagged for reverification. She is asked to come in for a re-interview. She has done nothing wrong. Her records are clean. But she is terrified because she does not fully understand what this process means, and she cannot afford an attorney. This is the human cost of enforcement expansion, not just for those who committed fraud, but for the thousands of law-abiding people who get caught in the machinery of a system operating at accelerated speed. Amara's situation is not hopeless, but it is urgent, and knowing what to do next and what not to do is everything. So what should you do if any part of what I have described today applies to you or someone you know? Here is a structured, realistic action plan. Step 1. Audit your immigration history immediately. Pull together every document related to your naturalization, your green card application, your visa history, your asylum or refugee case. every form you submitted, every document you provided. If there are inconsistencies, even small ones that felt unimportant at the time, you need to know about them before USCIS does. Step 2. Do not respond to any government notice without legal counsel. If you receive a letter, a notice, a request for evidence, or anything from USCIS or DOJ related to your status, do not respond alone. Do not assume it is routine. Contact a licensed immigration attorney before you take any action. Step 3. Verify your attorney or consultant. This is critically important right now because every time there is enforcement news like this, immigration scammers surge. They target frightened people with promises they cannot keep. Verify credentials. Use State Bar Association websites. A notario is not an attorney. An immigration consultant is not an attorney. Only a licensed attorney can represent you in legal proceedings. Step 4. Monitor USCIS and DHS communications directly. Go to uscis.gov and dhs.gov. Subscribe to official newsroom updates. Do not rely solely on social media or secondhand sources, including this channel, as your only source of information. I provide analysis. Official government sites provide policy. Step 5. If you are in the Minnesota refugee population specifically, or you entered as a humanitarian parolee, contact a nonprofit immigration legal services organization immediately. Many offer free or low-cost consultations, and given the active nature of Operation PARRIS in that region, early legal guidance is especially important. Now let me zoom out and give you the broader policy picture, because understanding where this is heading is just as important as understanding where it is right now. Operations like Twin Shield and PARRIS are executive branch initiatives. They do not require congressional approval to operate. They draw their authority from existing statute, primarily the INA, and from the administrative powers granted to DHS and USCIS. However, this does not mean they are legally unchallenged. Civil liberties organizations are already monitoring the scope and application of these operations closely. Federal courts retain the power to review denaturalization proceedings. These are civil cases that go through the federal court system, and defendants have due process rights, including the right to legal representation and the right to contest the allegations against them. This protection may not be permanent in its current form if broader legislation narrows judicial review in immigration cases, something that has been discussed in various congressional proposals. But as of today, the federal court system remains the check on executive enforcement overreach. What this means practically is that the speed and scale of these operations will likely continue to expand throughout 2026, particularly as data sharing between federal agencies improves and historical records become more accessible to investigators. The realistic timeline for seeing the full impact of Phase 2 is 12 to 24 months, but individual cases can move much faster than that. I want to close with something I say carefully and intentionally. Your immigration status is not just paperwork. It is the foundation of your family's unity. It is the security behind your employment, your mortgage, your children's future. It is the difference between staying in the country you have built your life in and being forced to leave it. Operation Twin Shield is not a political talking point. It is an active, funded, multi-agency enforcement operation with real consequences for real people who made real mistakes in their applications, and in some cases, for people who made no mistakes at all, but find themselves inside a system that is moving faster than they can respond to. Staying informed is not optional right now. It is protective. It is essential. And the best thing you can do for yourself and for the people in your community is to understand what is happening, consult qualified professionals, and not panic. Panic leads to bad decisions. Information leads to good ones. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It is essential. If this video helped you understand what Operation Twin Shield means for your situation, please leave a comment below. Tell me your visa category, whether you are naturalized, a green card holder, a refugee, or still waiting on your case. I read every comment, and your questions help me decide what to cover next. If you know someone, a family member, a friend, a coworker, who has immigration questions right now, share this video with them. It could be the most important thing they see today. And if you believe factual, legal, non-sensational immigration content matters, give this video a like. It helps this channel reach the people who need it most. I will see you in the next update.